Man, this should be a quick one. So what I was doing again, you guys, I follow the white rabbits down the hole, right? I see something, and I just keep chasing it. I was looking at different cases against the Putnam Sheriff Department for a future video that I would like to do if I can get more information from the attorney on the case. About something that happened over a year ago over there in Putnam County. I'm sure some of you have already seen that video. And I'll be covering that as soon as I find out about any lawsuit that might be filed. I can't find it. But anyway, when I was doing that, I was looking at all the cases that had been filed in federal court against Putnam County. And came across this little nugget. And what I was doing, I was looking at who the plaintiff is. AB, well, that's kind of weird. Sheriff Tusing, and then the Sheriff's Department. Okay, so I was just browsing through this, and what I do when I notice that the case is closed is I come down here to the last order, and normally I see an order of dismissal for some reason. It's always closed or it's dismissed. Sometimes it's closed. I was just on another one of these that it said closed for the plaintiff not showing cause for why it didn't serve on the defendant or something like that, right? So there's always reasons why a case would be closed. And so I go down here to the bottom. Am I going to bother wasting my time reading it and paying for the documents? Because yes, each page costs me money. And so it's fun. Okay, so order of dismissal. Having been advised that all matters have been settled in compromises, action is dismissed with prejudice, with the parties to bear their own costs and attorney's fees. Signed by Judge Joseph R. Goodwin. So we know that this settled. Interest is piqued. Why would they settle? They never settle, right? Well, okay, they do. They settle a lot. So it's important to note this case happened in 2007. Let's pull up the case. And this is the complaint as argued. The plaintiff here, AB here, and referred to as the plaintiff, brings this action against them. Defendant C.S. Tusing for their actions against the plaintiff in violations of protections afforded the plaintiff under the 1st, 4th, 5th, 6th, and 14th Amendments. We're used to 1st, we're used to the 4th, 5th, and 6th. Those are attention grabbing because we rarely see 1983 cases involving those unless they involve questioning. So was this somebody who was just beat? That again, this is the stuff going through my head. 14th Amendments. 14th is very broad and open, so it could be multiple things there. Amendments to the Constitution as well as federal common law for their actions in violations of protections afforded plaintiff under the Articles 3 and 7, or 12, of the West Virginia Constitution and common law of West Virginia. Plaintiff at all times relevant, a resident of Putnam County, West Virginia. Defendant, Sheriff's Department, blah, blah, blah. Defendant C.S. Tusing was at all times relevant herein, a resident of Putnam County, West Virginia. Just a resident, not an employee, is what this says here. Interesting, right? Facts. On or about February 12th, 2007, county sheriff's officers were called to the home of plaintiff following a domestic violence report. Domestic violence charges were filed against Jerry A. Simmons, former boyfriend of plaintiff. Wait, so they arrested her boyfriend for beating her, and she's suing them for all those constitutional violations we talk about up there. Again, everything about this was just jumping out at me like, go get what's going on here. Defendant C.S. Tusing was one of the officers who responded to the aforementioned call. Okay, so that didn't give me the actual. Okay, Mr. Simmons was taken into custody and removed from plaintiff's home. Then defendant Tusing began questioning plaintiff regarding the domestic violence report. The questioning began inside a police vehicle for a period of approximately 10 to 15 minutes. The interview was recorded by defendant Tusing. Okay, so they went into his police car to ask questions. Defendant Tusing then escorted plaintiff back into her home without another officer to accompany them. Dun dun dun! Now I think you can see where this is going. Defendant Tusing began to take digital photographs of any sign of damage within the house. That seems proper. Right? All this right here. I don't know why it's doing this instead of the normal selection I get. Yeah, like that. Okay. Defendant Tusing asked if plaintiff suffered any injuries as a result of domestic altercation with Mr. Simmons. She advised defendant Tusing that she was injured near her elbow. Then Tusing asked if plaintiff suffered any injuries in the areas of her neck or chest. She advised that she did not have any indications of injuries in the areas of her neck or chest. Tusing then informed plaintiff that he would require photographs of plaintiff's neck and chest areas, even though she suffered no injuries to those areas. So he says that even though she suffered no injuries to those areas, he still needs to take private pictures. Yes, he did go there. Defendant Tusing instructed plaintiff to lift and remove her clothing so that her chest area was uncovered so that he could take digital photographs of the area. Really, you guys, this case is not funny to me. This case is very serious to me. I am laughing about the absurdity of it. I do not find what happened to this woman funny at all. But the absurd behavior of the police, knowing that they most likely will get away with it, still galls me to this day. He didn't think he would get caught, or he didn't think any of her complaints would fall on, would be heard. Defendant Tusing made certain suggestive remarks while taking digital photographs of plaintiff's uncovered chest. Yes. Not only did he take pictures of her chest, but he was making suggestive comments about it. Plaintiff did not consent to the unnecessary photographic evidence, but felt she had no choice but to comply with the direction of defendant Tusing. So, I want to put this in perspective. This woman was just victimized by a man. She was attacked by a man. And then she was attacked in another way by a law enforcement officer. No female officers were present during the time defendant Tusing conducted his photo shoot. After taking the unnecessary photographs, Tusing asked plaintiff for her phone number, which he wrote on the back of his hand. He then informed plaintiff not to worry, that he would not call her to come back and take more boob shots of her. Yeah. Plaintiff was taken advantage of and victimized by defendant Tusing during a time when she had already suffered as a victim. Oh, yeah, so they say exactly what I just said. At a time when she had already suffered as a victim of domestic violence. In those times of need, we should be able to turn to those that are in power to protect us. We should be able to do that. I don't. I can't. But that should be the goal of the system, isn't it? To be able to turn to those police officers who are supposed to be there to serve and protect us. We should be able to turn to them for comfort. Maybe not comfort. Maybe that's the wrong word. but for protection. Not this. They assigned the complaint to Sergeant Lisa Arthur for an internal investigation. Upon information and belief, no disciplinary action has been initiated or taken against defendant Tusing. On or about April 26, 2007, the criminal prosecution of Jerry A. Simmons for domestic violence against plaintiff was brought on for hearing in Putnam County. Prosecuting attorney assigned to the domestic case was not provided any photographs taken by Tusing on or about February 12, 2007. So the digital photographs taken by defendant Tusing as a requirement for his investigation suddenly became expendable and not part of the subsequent prosecution. More importantly, those digital photographs were withheld from review by the prosecuting attorney assigned to the case and thus intentionally deprived the prosecuting attorney of key evidence. Upon information and belief, personnel within the Putnam County Sheriff's Department intentionally withheld the photographs as part of its efforts to absolve itself and defendant Tusing of any liabilities for the acts of defendant Tusing. Count 1, invasion of privacy. Defendant's actions and inactions constitute an invasion of the plaintiff's right to privacy as protected under federal and state law. Count 2, violations of the civil rights. Defendant's acts and omissions constitute violations of the plaintiff's civil rights as protected by the 4th, 5th, 6th, and 14th Amendments to the United States. As direct and proximate result of the defendant's aforesaid actions, plaintiff has suffered and will continue to suffer damages in an amount to be proven at trial. As a direct and proximate result of the defendant's aforesaid actions, the plaintiff is entitled to judgments for indignity, embarrassment, humiliation, emotional distress, annoyance, and inconvenience in the amount to be determined by the jury. His actions were willful, wanton, malicious, and undertaken with reckless disregard and reckless indifference to the rights of the plaintiff, entitling the plaintiff to punitive damages. Count 3, tort of outrage. I love this one. We don't get to see this enough in courts. It's not often used, so not all states actually have this, and so it's really cool when we get to see it. Offense constitute an intentional infliction of emotional distress in plaintiff in violation of the common law of West Virginia and federal law. Plaintiff has suffered and will continue to suffer emotional distress in an amount to be proven at trial. Intentional infliction of emotional distress. Again, you guys, I want you to think here. They were there to protect her. They were there to arrest somebody who was beating her, and they violated her in this way. Assault. Assault would be harder, constitute a civil assault upon the plaintiff in violation of West Virginia. They don't actually say how, so can't argue for or against it. Can't throw the book at them, right? Violation of the substantial public policy of the state of West Virginia. Violation of West Virginia Human Rights Act. Negligent hiring, training, and supervision and retention. Gender discrimination. Okay, yeah, well, it's a good cause because you wouldn't ask a guy to show you his boobs, right? Theoretically. Strict liability for the agency. Defendant C.S. Tusing is an officer, agent, or supervisory level employee of Putnam County Sheriff's Department at all times. He was acting within the scope of his agency and employment with the Putnam County Sheriff's Department. Civil conspiracy. Spoliation of evidence. Wow. Prayers for relief. Compensatory and punitive damages as set forth in this complaint in an amount to be determined by the jury. Pre-judgment interest as provided by law. Post-judgment interest as provided by law. Attorney costs, fees and costs, and any further, anything else further deemed by the courts. Pretty well pled, assuming all facts are true. How do the cops reply? Oh, even more fun. First offense. So first, come on, close this. Thank you. They failed to state a plan upon which relief may be granted. Oh, so even if they do, they lack information, so they can't admit or deny. They admit some of these statements here. Then in the facts, they admit to the extent that they advise she suffered injuries near her elbows. So this is where they start to deny, which is smart, right? She was grabbed all over, and then they further state that the plaintiff advised Corporal Tusing she was grabbed all over by Jerry Simmons and suffered injuries to other areas of her body, including her upper body, back, and arms during a wrestling match with Simmons that lasted 20 minutes. So even though she said no, she doesn't have any injuries on her chest, they say that she told him this. Okay? Then they deny. What was paragraph 20? What are they admitting there? Sorry, you guys. I know this gets dizzy watching that. No female officers were present. So they are admitting that there were no female officers present. These defendants admit that Corporal Tusing asked for plaintiff's phone number for investigative purposes and then wrote it on the back of his hand, as he did not have any paper at the time. How many have you seen cops, have you seen go into an investigation, start taking hundreds of photos of evidence without a piece of paper in their pocket? Raise your hand. No, Then the defendants deny the remaining statements and allegations contained in paragraph 21. So they deny that he made bad comments. They deny, admit. So where do we start with number 23 here? So they're going to admit, and so that deny. You know what? What else are they supposed to do here, right? To the extent that any of the preceding affirmative defenses are applicable based upon the evidence adduced in this matter, these defendants invoke the following defenses of accord, satisfaction, arbitration, and award. Okay, expiration of the statute of limitations. Assert, preserve the defenses of immunities contained in West Virginia Code. Okay. Raise and preserve defenses of qualified immunity and any other immunity available to this third-party defendant pursuant to the United States Constitution, United States Code, the West Virginia Constitution, and the West Virginia Code. Yes. Yes, they did. These defendants hereby raise and preserve each and every defense set forth in Rules 8, 9, and 12 of the Federal Rules of Civil Procedure, further reserve the right to raise such additional defenses as may appear appropriate following further discovery and factual development. These defendants, just more of the same, and they request a trial by jury. And I can't even find a story about this online. I can't find any news reporting about this. Maybe I'm missing something obvious. I really was trying. I want to find something. So if I find more information, maybe how much the settlement was for. This is an egregious case. So, all the cops can do is deny, because to admit would be bad for them. But the allegations, if true, holy cow, 2007. This was not 1954, right? 2007. Wow. Anyway, you guys, I am going to leave it there. That's actually 20 minutes. That's about 5 minutes longer than I wanted to be talking tonight. But this was just too interesting not to share. And look forward to doing more with you. Have a great night.